Good morning to everyone, and thank you so much for joining us. I'm Tim Gordon-Grant. With me is James McKinnell.
Morning, everyone.
We are both senior, as is obvious, especially in the case of James, commercial litigation partners at Moments. I have been asked to just read something out to you. We're going to be discussing shareholder claims, as you know. There are a few housekeeping issues which should enhance matters. As participants, you're all automatically muted, and the chat functionality has been disabled. But you should you have any questions, and this we encourage, please make use of the Q&A tab at the bottom of your screen. Your typed questions will be visible to James and me, and we'll do our best to deal with as many as possible during this webinar. Finally, this webinar is being recorded, and a copy will be available on our website later today at www.bowmanslaw.com. So we're talking shareholder claims. So we're really dealing with a dynamic between shareholders on the one hand and directors or senior officers of the company, and also the auditors of the company on the other hand. And we're dealing with two specific concepts that were dealt with by two courts, both very much simultaneously, and which have brought a lot of clarity to the way things are in our law at the moment. Firstly, we're dealing with what we call common law liability, where a shareholder is permitted to claim losses from a director of a company or the company itself, or a senior officer of the company, or in fact from the auditor of the company. We're dealing with delictual liability here. It's not contractual. In other jurisdictions, it's referred to as tort. And there are certain elements that have to be present for liability to be available. A short example of what directors are looking at when they lie down at night, perhaps, is if any one of you is standing in the street and a bystander comes to you and says to you, I have a very important meeting and there's a lot of money involved and I don't want to be late. Can you please tell me the time? And you look cursorily at your telephone and you tell him it's 9:30, when in fact it's 11:30. So relying upon that, he goes off and sits in a park and has some coffee, and he ends up missing his meeting. And there were only two people who were going to be at the meeting, he and another tenderer with the tender committee. So the other person got the tender, and the person who lost out, to whom you gave the wrong time, loses out, let's say, on 100 million rand loss of profit. Now, in giving him the time, you're probably negligent, because you knew it was an important meeting and there was money involved, and you didn't take proper care. The fact that you caused him damage is fairly obvious and uncontentious as well. He missed the meeting because of your negligence, and as a result, he lost out on the tender, and he could establish that his price would have been a lot lower and more competitive. So why shouldn't he be able to sue you for 100 million? Why should a shareholder not be able to sue you as a director for a 100 million drop in the share price because you and your other board members took a specific type of decision, which was perhaps negligent and caused the company to go in the wrong direction? Well, the answer is that there's one more element of delict which needs to be present before liability can accrue, and that is wrongfulness, and that is what we will deal with here. Now, to add to that, if you're a director looking at potential liability or an auditor, along comes Section 218 of the Companies Act, which is no longer that new. I I think James is going to put it up for us. If I give him a sec. Now, if you look at section 2182, it's very short and it's very draconian. As you can see, it says any person who contravenes any provision of this act, so it's anyone who breaches any provision of the act, is liable to any other person for any loss or damage suffered by that person as the result. Well, there you are. That's the example I gave you. And if one puts that example in here, there it is. So the slightest contravention of the Act could bring into play section 2182, and you as a director will be praying and hoping that your insurance cover covers everything you do and in a sufficient amount. Because when we're talking about dropping of share prices, take Steinhoff, for example, like 50% drop in the share price of a public company, you are talking massive amounts, which I think many insurance policies probably don't fully cover. So those are the issues. And then along come these two cases. The one we call the Steinhoff case, which was heard in Johannesburg, and the judgment was delivered by Untitled Chapter, who I think is known to many of you as previously being a very eminent senior counsel. He delivered his judgment on the 26th of June. And this was a case brought against Steinhoff, its directors, and its auditors, Deloitte. And then a week later, another judgment came out on the 3rd of July, which is, the case is called Hlumisa, but we refer to it colloquially as the African Bank judgment. And their African Bank directors and its auditors, again Deloitte, were sued. Now these judgments seem to have been written virtually simultaneously, contemporaneously. And what is very interesting is that they complement and confirm each other. Of course, the Hlumisa case is a Supreme Court of Appeal case, which is the second highest court in the land. But they complement, as I say, and confirm each other. So when I am talking, I'll be talking largely about the Steinhoff case, just because my personal preference is I enjoy the writings of Untitled Chapter. But what is comforting as well is that they both came to the same conclusions on all the main legal points. So these cases also, finally, for my introduction, deal with the concept of reflective loss, the loss of a shareholder reflected in the share price, and whether you can or cannot get that loss. So it's fitting that the facts of these cases came up and were dealt with at very much the same time. And I will then now hand over to James to deal with how these cases came about and what happened. Thank you.
Thanks very much, Tim. And good morning, everyone, again. Tim, I think you put your finger on it. It's incredibly interesting that both of these cases came up at the same time. I'm going to just introduce the cases and very briefly go through the facts, because I think it's important when one considering the rules which were confirmed, I think, largely and expanded upon. It's important to understand the context, not just of the facts of these particular judgments, but the reasons why, the legal reasons why the decisions were made. So firstly, let's talk about Steinhoff. I should make a disclosure at the beginning that we do have several involvements in Steinhoff. We act for various so-called vendor claimants. I personally advise some of the bondholders, most of the bondholders right at the top of the structure. They used to hold about 1.5 billion euros of bonds. But everything we discuss today is obviously publicly available information and completely confidential in a sense. And obviously any views expressed are those of Tim and me, not any of our clients. So I think people know about the Steinhoff Group. It grew rapidly in the last decade, and really I think a seminal time in the group's life was in 2015, when the then CEO Marcus Jooste entered into various transactions with various parties. Some parties subscribed for large numbers of shares, new shares in in the group. Some parties swapped shares. They swapped PSG shares and other shares for Steinhoff shares. And then what the group did in 2015, at the end of 2015, it did a scheme of arrangement. At that time, the apex company in the group was listed in Johannesburg, what we call SIHPL, listed in Johannesburg. It externalized all of its assets to a Dutch company, and through a scheme of arrangement, all assets were moved offshore. The South African company delisted, and the Dutch company listed in Frankfurt, and then listed again as a secondary listing back in South Africa. So effectively, everyone who was in the South African listed company became a shareholder in the Dutch listed company, and obviously many other parties bought shares both on the Frankfurt exchange and also back in the South African exchange through the dual listing. And the seminal moment in the group's life was on 5 December 2017, Tim, and you talk about a drop in share price. On that day, the company issued a very important announcement and said that certain accounting irregularities had been uncovered. The CEO resigned, and the publication of the financials was delayed, and there was an announcement that there was going to be a forensic investigation by PwC. And from a high in March 2016, when the company had listed, you had a share price of 95.80 Rand, a market cap roughly at listing in March 2016 of around 300 billion Rand. In one day, the share price fell 62%. It dropped down to about 5 Rand on the 5th of December. And now, obviously, it fluctuated, but now it's generally trading at less than a Rand. So for a shareholder who bought their shares on the listing in Frankfurt in March 2016, they've lost more than 99% of the value of their shares. Just to give you an idea of the assets one's talking about, in March 2020, unaudited financial statements, assets still of about 14.9 billion euros, still in the group, but negative equity because of the substantial claims which have been brought against the group, negative equity of 3.5 billion euros. So that really talks about the spectacular collapse. Various claims have been brought against the group, and I think one should just distinguish between what I refer to as so-called vendor claimants. These are claimants who subscribed for shares or who swapped shares with the group, so they entered into a contract with the group. As Tim indicated, those are contractual claims. That's not what we're discussing today. There are many of those claims brought against the group, but those are contractual and those are not dealt with by either of these judgments, obviously. Then the shareholders in Steinhoff brought various class actions. There are 2 abroad and 1 has been brought in South Africa, and that's what we're discussing today, the Steinhoff judgment. Just to refresh, so people are aware of the procedure, class actions in South Africa go through a 2-stage procedure. Many may know that there aren't actually parliamentary written rules which govern class actions. They are being defined by judges in various cases as we go. There is a draft bill dealing with and regulating the process for class actions, but it's never been passed into law. So what we found since the class actions were permitted in civil claims is courts defining the rules as they go, and generally with respect doing a very good job of that. So this application comes to court where the applicant seeks certification. She wants to be certified. She wants 3 different classes certified, and she wants to represent all shareholders who wish to participate in this class action. And generally the test which the court faces here is whether it's in the interest of justice to certify the class. And there are various considerations. They're not really requirements, but there are considerations which are considered and which Untitled did consider here. I'll just run through them very briefly. Is the class identifiable by objective criteria? Are there sufficient issues of fact or law which are common to all members of the class? Is the relief sought or damages claimed? Does that flow from the cause of action? The principle of allocatability, in other words, is there a procedure to allocate damages fairly amongst the different members of the class? Representation, is the class representative suitable? Is her representatives, the legal representatives, are they suitable? Are there appropriate arrangements, etc.? And appropriateness, is this the most appropriate way to pursue the class or the cause of action, rather, the claim? The most important consideration, certainly in this case, is whether the cause of action raises a triable issue. So in other words, whether the cause of action proposed is tenable in law. And that's a threshold which Tim will touch on, but that's what Untitled found, whether it's tenable in law, not just merely arguable, it's got to be tenable in law. And what that means is that the cause of action must survive the test on exception. In other words, can the respondent show that on every interpretation that can be put on the facts to be proven, the applicant has made out no cause of action? And obviously, as you'll know, in exceptions, the court assumes that the facts will be proven for when testing a cause of action. And that was a very, very important, it's a very important principle to be made. So what claims were brought? Well, the claims that were intimated in the certification application is that the shareholders said that there were so-called impugned transactions. There were various transactions which they complained of, which occurred within the group. And they said that these transactions overstated the income and the assets of the group at various times and understated the liabilities of the group at various times. And they complained against the directors and many other parties, including the auditors as well. And so the claim was originally brought against 42 parties. It was later narrowed down to, I think, 23 or 24 different parties. So that's really the Steinhoff facts. African Bank, as Tim has touched on, the claimants here, Hlumisa and Umhlaba Investments, were two minority shareholders, together held just over 5% in ABIL, African Bank Investments Limited, which was listed in South Africa. That owned a subsidiary, which in turn owned African Bank, which was the well-known bank. These two shareholders, it wasn't a class action, it was an ordinary action. They sued the directors for breach of their fiduciary duties in terms of Section 76(3). They said that, or they alleged that the business of the bank had been carried out recklessly and with gross negligence, leading to significant losses by the bank. And they sued the auditors for their alleged failure to take sufficient steps to disclose and rectify the true state of affairs at African Bank in the financial statements. Similar to Steinhoff, the bank, once it became known that it was suffering significant losses, the ABIL share price crashed. It dropped from a high of 28.15 Rand to 31 cents. So that's, again, a 99% drop in the share price. And it caused these particular shareholders losses of 721 million and 1.341 billion, respectively. Importantly, and just before I hand back to Tim to actually decide to talk about what was decided, importantly, this case was also decided on exception. And that's important because the facts, in a sense, are assumed on exception, and the court is really focusing on the law. And just to quote from the judgment, the well-known test, it is for the excipient to satisfy the court that the conclusion of law set out in the particulars of claim is unsustainable. The court may uphold the exception only if it is satisfied that the cause of action or conclusion of law cannot be sustained on every interpretation that can be put on those facts. But the facts, in a sense, assumed, and both courts really focusing on the legal tests in both cases. So Tim, over to you. What was decided?
I was just unmuting myself. Thank you, James. All right. So what is the current position following these judgments for shareholders and their potential claims against directors and against auditors? Please, we must accept as a given, because it's not really the subject of today, that a company has remedies against its directors for their conduct. And those remedies are clear and well stipulated both in common law and in the Companies Act. And they're based upon contract, and they're based upon things like fiduciary duties. Similarly, a company has remedies against its auditors, usually founded in contract, because there would be letters of appointment or contractual relationship between the company and the auditors. And if the auditors breach that agreement, they're liable to the company. So those are givens. The question here, going back to my example about the giving of time, is that the law says to you who gave the wrong time that you have no duty to the person who asked you for the time. And therefore that person cannot sue you. And the findings in Steinhoff and Hlumisa, or African Bank, when it comes to company directors, is that they have no general duty towards shareholders of the company. The second most important finding is that Section 2182, which we put up on the screen earlier, which has this general and draconian provision for liability. The courts found that this section on its own does not give rise to liability. When it comes to auditors, similarly, the court found that the auditors in performing the audit, in working on the annual financial statements, owe no duty to the shareholders of a company. Similarly, Section 218 does not assist because it does not give rise to liability on its own. The courts also in the auditor category dealt with certain provisions of the Auditing Profession Act, which I'll touch on briefly. So when it comes to the common law of dealing, the liability directors might have to shareholders. If I can quote from Untitled J's judgment, he said that the issue that then arises is whether Steinhoff, their directors and Deloitte owe any duty of care to prospective purchasers of Steinhoff shares who go on to buy the shares, or to shareholders who decided to hold their shares rather than sell them. So what he's talking about here, of course, is, and putting it in very simple terms, a prospective buyer of Steinhoff shares looks at the annual financial statements, relies upon them, and buys the shares. The question then is, did the auditors owe a duty, or the directors, in this instance, to that shareholder in regard to those financial statements? Or similarly, a shareholder who holds Steinhoff shares looks at the financial statements and decides this is all looking rather good, I'm going to hold on to my shares rather than sell them. Untitled recognized that it's well established that directors owe fiduciary duties to the company and not to its members, and the company is distinct from its members. And a very old and still most pertinent authority of 1843, the case of Foss versus Harbottle. The company has an action, as opposed to shareholders, for wrongs done to the company. So the finding in Hlumisa, African Bank, and Steinhoff is that there is no general duty owed to shareholders or prospective shareholders by the company or its directors. And that then deals with the question of common law liability. Of course, and perhaps we haven't mentioned it, these cases aren't necessarily going to be the last word. The African Bank case is the Supreme Court of Appeal, but if there is still a constitutional court that may well pronounce on these things, or the Supreme Court of Appeal itself in another case. The Steinhoff case, of course, is a decision of a single judge in the Johannesburg High Court. Coming to the auditors then, and the case against Deloitte in African Bank and Steinhoff. The courts have found that the auditors must give a true and fair view of the company's financial position. And this is a duty owed to permit shareholders to exercise their rights as shareholders in respect of governance of the company only. It is not a duty owed to permit shareholders to make investment decisions, whether to buy or sell shares. So there again, the courts found there is no general duty of care owed by the auditors in working on the audited financial statements. There's no general duty of care to shareholders of the company. That deals with the common law. If we get to the statutory regime then, the Companies Act has a regime of liability for particular contraventions. If you go through it, you will find numerous sections which specify an act, specify an offence, specify a consequence, and specify who is visited with that consequence and in favour of whom. One needs to look to the particular section to be sure what and where that liability lies. Let's give you an example, which is on your screen. Section 77, 2, the liability of directors. A director of a company may be held liable, and it sets out under the common law for breach of fiduciary duty, and it deals with common law intellectual rights. But in both instances, the section quite clearly says, sustained by the company. In the second line of section 77.2a, it says for loss, damages, or costs sustained by the company. Similarly, in subsection B, loss, damages, or costs sustained by the company. And these courts have found that that section gives the company the right to seek recompense from a director who breaches this section. This section does not give a shareholder a right. It only gives the company a right. So another example was, if you look at section 22(1) of the Companies Act, which I will quickly find, which makes a very general statement, and there it is. A company must not carry on its business recklessly, with gross negligence, with intent to defraud any person or for any fraudulent purpose. You'll notice there that there are all sorts of fault elements that come in. It's not strict liability. There must be recklessness, negligence of a gross type, or intention, and fraudulent purpose. Now, people were very keen then to take that section and marry it with section 218 to say, well, if a director breaches section 22 and causes a company to act in this way, then you take section 218, which says anyone who contravenes any provision of this act is liable, and hence you have liability. Well, these decisions have found that that is not the case. Section 218 doesn't create any liability, and you must go to section 22(1) on its own, which says a company must not carry on its business recklessly. That doesn't impact upon a director in the normal course. It may well create an offence, and it may well create certain types of liabilities, but it doesn't on its own. And in the absence of section 218, which doesn't assist, according to these decisions, it doesn't create that liability that people seek. The courts, and particularly Untitled, have found that you cannot interpret section 218 literally. It recognizes that there's a liability for loss may arise from contraventions of the Companies Act. What that right consists of has to be determined by reference to specific sections of the Act. So it was also commented that section 218 alone doesn't deal with fault, it doesn't deal with foreseeability and remoteness. And standing alone, that section places such a burden of liability and risk on directors that it would be hard to imagine who would accept office on those terms. Why would I sit on a board if section 217 creates this draconian consequence for anything I do, which doesn't even require me to be at fault? So hence the section does not create liability, in my respectful submission, correctly found by these two decisions. If one also goes to, because this came up in these cases, section 20, subsection 6, which I'm just finding right now, which is not in front of you, you will see that section says that each shareholder of a company has a claim for damages against any person who intentionally, fraudulently, or due to gross negligence causes the company to do anything inconsistent with this act. again, it's draconian. And despite the wording of actually identifying the class of claimant and supposedly the class of defendant, the courts have found that this section is not available to shareholders. It is available to the company. So when it comes to directors' liability in terms of these sections of the Companies Act, these courts have pronounced upon it and limited it extensively. If I then turn to auditors and the statutory duty that auditors might owe, and I won't spend a lot of time on this because the time is running. In these cases, reliance is placed on Section 30 of the Companies Act, which deals with the audited financial statements and what is required in them. And there again, attempt is made to link that section with Section 218 to found a liability by auditors. Well, the courts quite simply found that if you look at Section 30, these are obligations which are imposed upon the company. They're not imposed upon the auditors. So that deals with that from these cases' points of view. Then, of course, the enabling section of Section 218 does not apply to the Auditing Profession Act. So the courts then turn to that act itself to see where liability may be found. And I'm just calling up the act in front of me in case I need it, and I have it now. If one turns to Section 46 of the Audit Professions Act, it's actually headed limitation of liability. It's a very peculiar section. In Section 46(2) sets out in a negative form circumstances where statements or opinions expressed by an auditor, the auditor doesn't incur liability unless certain things are proved. And the court found that this doesn't create an independent basis of liability on its own. Section 46(3) sets out that it may establish some kind of independent liability because it talks about the incurral by an auditor of liability to third parties, and it requires all sorts of factors to be present, such as negligence and various other issues that we would define as fault. However, this is all trumped by Section 46(4), which is the same section, but it's the end subsection. And this Hlumisa, the African Bank, stressed. It says nothing in subsections 2 or 3, which I've just dealt with, confers upon any person a right of action against a registered auditor, which, but for the provisions of these subsections, the person would not have had. So there, it quite clearly states that the provisions of Section 46 do not, in themselves, create a liability. So on that basis, in Hlumisa and Steinhoff, no claims could be found to be valid. Then there was also reliance placed on Section 45, which we know is the bane of many companies because it's the provision which casts a duty on an auditor to report reportable irregularities to IRBA. And there, the question was, well, if you don't comply with that duty as an auditor, then could you be liable to a shareholder as a result? So when you go to Section 46(7), and I'll stop quoting sections shortly, it says that a registered auditor may incur liability to, inter alia, a shareholder or member, if the auditor fails to report a reportable irregularity. Now, despite that wording, it was found by Untitled Chapter that that subsection does not create a self-standing basis for liability. So based on these various sections, the claims against Deloitte in either case could not be sustained. And finally, and very briefly, there was some reliance placed on IFRS, which is in fact, I think, very much misplaced, because IFRS is a standard. It's not what I would call, or what we could call, law. And it may well be used as a standard that you would apply in determining liability in other areas where one is looking at things like negligence. But IFRS on its own was found in these cases not to be, in the case of Steinhoff, found to be not a basis upon which liability could be found. So that, in short, is how these cases dealt with potential liability of auditors and directors and prescribed officers. And I think very sensibly so. So one then is left with one final question on this. When, in fact, do shareholders have rights? Or rather, when can shareholders sue directors or auditors? Well, and this was dealt with quite a lot by Untitled J in Steinhoff. Everything that I've said does not preclude liability arising if there is a special factual relationship in a given instance. And there's no closed list for that. Examples given by Untitled J is if, for example, directors persuade an outside shareholder to sell their shares to the directors, and representations or statements are made upon which reliance is placed. That's a special factual relationship. It doesn't give rise to a general duty. Another is where directors make representations to shareholders to secure options, undertaking to sell shares of shareholders. There again, you're looking more at a quasi-contractual or delictual situation where a special duty arises in a special circumstance. It's not a general duty. The seeking of approval of shareholders for a transaction may give rise to a duty to provide sufficient information to the shareholders. And if the directors don't provide that information, they may be found in that special circumstance to be failing in a duty. And the same, I think, applies to auditors. If an auditor has dealings with a shareholder and makes statements about a company or gives certain assurances, that is also a special circumstance. So there, of course, those remedies are available. Of course, the old Section 424 of the Old Companies Act, which deals with reckless trading, which really only applies now in a winding up situation, that, of course, creates remedies as well, and personal liabilities. So it's not a closed list. But the point is, Section 77 is not available to shareholders. It's available only to the company. Section 20, subsection 6, is available only to the company. And the delictual liability, the general delictual liability, is not available to the shareholder. And of course, James will deal with this. We have the derivative action, which is codified now as the only derivative action available in our Companies Act. But let us not forget, that is not an action for a shareholder loss. It's an action that a shareholder can force the company to bring, or bring in the company's name, for the company's loss itself. I could go on, but time is limited. So I will now hand back to James for the remainder of the questions. Thank you.
Thanks very much, Tim. So just to put up the discussion points you've covered so far, I think what you've led to now, Tim, is a different principle which cuts through both cases, and that's the question of reflective loss, because that's what both of these cases deal with. If you think about it, both shareholders, if they bought shares worth 100 Rand they lost 99 cents worth of the value, and that's really what's been suffered. And that obviously is the question of loss in the hands of a shareholder is a different question, and a very important one. It was largely more focused on in African Bank than in the Steinhoff judgment, which really touched on it. But what is reflective loss? In both of these examples, essentially, reflective loss is loss which is suffered by the shareholder because it's merely a reflection of the loss suffered by the company. The only loss suffered by the shareholders here is the diminution in value of their shares. And why did the share price drop? Why did the value of their shares drop? Because of harm done to the company. And as you pointed out, Tim, the rule that any loss which is suffered by a company can only be actionable by the company. That's a very old rule, as you pointed out. It's over 175 years. That comes to us from Foss versus Harbottle. And a different way that it's been expressed in many cases over the years is that the company is the proper plaintiff. It's also the proper plaintiff rule. In other words, only the company is the proper plaintiff. It's quite important because I think when one considers the future of shareholder actions and class actions, I think one has to always bear in mind the impact of this principle and the principle of reflective loss. So it's worth touching on some of the justifications, which mostly the English courts, but also adopted largely by South African courts, the justifications for having this rule, namely that shareholders cannot bring these claims for reflective loss. The first one generally identified is to avoid double recovery by the shareholder. Because if you think about it, if the company suffers loss of 100 Rand because of wrongdoing to it, and it sues the wrongdoer, and the wrongdoer pays the 100 Rand, the value that's been lost by the shareholder will automatically be restored. If the shareholder had also sued the wrongdoer and also got paid 100, the shareholder would have been enriched. So it would effectively amount to a double recovery by the shareholder. And the corollary to that, obviously, is that the wrongdoer suffers the risk of a double jeopardy. So if the director in this case got sued for the 100 Rand, they would pay the company and they would have to pay the shareholders as well. And that's the corollary. So there's the risk of double jeopardy to the wrongdoer. Some cases have identified that it's really a question of causation. They say that if the company chooses not to claim against the wrongdoer, then the loss which is suffered by the shareholder is actually as a result of the company's decision. So it's a question of causation. It's not the wrongdoer's wrong, it's the company's decision not to actually proceed against the wrongdoer that causes the loss. Other cases have identified public policy. They say the public policy of avoiding conflicts of interest. So if there was this multiplicity in a sense of potential actions, wrongdoers would be discouraged from making settlements because you wouldn't want to settle with a company claiming against you if you knew you'd still face a claim from the shareholder. So there's a policy element, and courts have identified that as a justification for the rule. Ultimately, one of the most powerful reasons that has come through the jurisprudence is that if the shareholder is allowed to recover in these circumstances, then ultimately it's going to recover at the expense of the company and its creditors and other shareholders, because effectively it's jumping up the ranking. But I think it's important to focus on, particularly in the African Bank SCA judgment, because that judgment dealt with it, looked at various of the justifications and over the centuries really, and it focused on the following justifications. It said that there's really a need to preserve company autonomy, and it's almost a philosophical question. And I'll quote just a small piece of the judgment. It says, since the shareholder shares are merely the right to participate in the company on the terms of the MOI, which right remains unaffected by a wrong done to the company, a personal claim by a shareholder against the wrongdoer to recover a sum equal to the diminution in the market value of his or her share, or equal to the likely diminution in value, is misconceived. In other words, it's obviously a philosophical way of saying your role as a shareholder is limited to your participation as a shareholder, and you cannot go beyond that. The assets of the company belong to the company, and your only participation in that is as a shareholder. Another principle which the SCA also cited with approval is that where harm is wrongfully caused directly to the company and indirectly to the company's shareholder, the law gives the right of action to claim compensation to the company. It does so because if instead the right were given to the shareholder, the company and its creditors would be prejudiced. And the judgment cites specifically Professor Blackman's work, which really, Blackman says that the notion of double jeopardy is incorrect, and the notion of double compensation is incorrect. They point out that in these circumstances there is a direct loss to the company, and there's an indirect loss to the shareholder. But they say for that reason that I've just expressed, you don't want to give the right to the shareholder, because if the shareholder were allowed to participate, they'd effectively be competing with the company's creditors. And that is a fundamental change in the notion of a company. Shareholders and creditors have completely different roles and rights. And if you allow this to happen, shareholders effectively compete with creditors. And in a sense, that's exactly what, to some extent, is happening in the Steinhoff matter, because you obviously have creditors' claims, and then you have shareholders' claims, and then you've got the class action creditors' shareholders' claims as well. So ultimately, though, the SCA very clearly reaffirms the principle and comes down very firmly, and it's important because I think this obviously will set the tone for future judgments, because it's obviously an SCA judgment. And the court finds there can be no doubt that when the Companies Act became operative on 1 May 2011, obviously referring to the new act, and thereafter, our law recognized the rule against claims for reflective loss, more particularly in respect of claims by shareholders for compensation for a diminution in the value of their shares due to loss occasioned to the company by a wrongdoer, and then cites various authorities. So there's a very, very clear statement that this is part of our law, remains part of our law, and is going to continue. Just a bit of food for thought on this topic. I think there's a difference. If one thinks about the African Bank judgment and the Steinhoff, or the African Bank scenario and the Steinhoff scenario, there's a slight difference. If one thinks of African Bank, the way I see it, there's alleged ultimately a breach of fiduciary duties, which led to reckless trading, which led to the company and the bank, and therefore its holding company suffering loss. So the bank would have had, the balance sheet would have looked much better than it did before the wrongdoing and the reckless trading and the losses which were suffered through reckless lending and all the rest of it. So there's a real loss to the company. I just wonder, and it's really food for thought, if you think about the Steinhoff situation, what is complained of is the inflation of assets, the inflation of stated assets, the inflation of stated income. The assets and the income were never there, so it's alleged. And the understatement also of expenses. So the balance sheet, although it may have looked better, those assets were never there. So if one just thinks about it and one says, well, the company suffered the loss, what exactly is the loss that is suffered by the company? It overstated its assets, so it's alleged. It's overstated its income, so it's alleged, and that occurred, that was compounded obviously through various years. That led to an inflation, some would say a false inflation of the share price, but those assets were never there. So just looking back at the principle of reflective loss, I'm not sure, if one thinks about it carefully, that it's definitely the last word on this topic, because the kind of loss suffered by the Steinhoff shareholders is not necessarily reflective of the loss suffered by the company. It may have had other losses. It may have had obviously indirect losses and direct losses, the costs of the forensic audit, etc., etc. But it's food for thought. And Tim, you touched on, you said that the African Bank judgment, although judgment of the SCA, we are aware, I think it's publicly known, that there is a petition to the Constitutional Court now in the African Bank matter. So that may not be the last word in that particular matter. And obviously, the principles, no doubt, will be tested again soon. So that's really reflective loss, the rule reaffirmed. I think very important in any matter in this instance. The next subject we thought we would touch on: when can shareholders use the class action or derivative action procedure? And I think here one can touch on really just I've dealt with the requirements and the procedure for class action claims. And if one looks at the Steinhoff judgment, you'll find that Unterhalter is in fact very sympathetic to the potential question of a class action. And in fact, just to quote he's upfront about it. He says that given the large number of persons who bought Steinhoff shares and suffered losses, there's every reason to consider that a class action may be an appropriate means by which these persons may gain access to the courts so as to litigate against those that they would hold responsible. And he signals and notes that it was raised for him. He says, so too it is said that if a class action is not certified in this case, given the scale of the losses suffered by Steinhoff shareholders, then the shareholders' class action is destined to extinction in this jurisdiction. And he pointed out right at the beginning of the judgment that this was novel. This is certainly, to our knowledge, this is the first shareholder class action of its kind in South African legal history. So Judge Unterhalter understood, and it was raised obviously before him, but he understood the importance of a precedent on this. And he then goes through and he considers the various, as I said, they're not requirements, but they are considerations which the court will apply in deciding whether it's in the interests of justice to certify or not. And he finds on every single consideration, he is in favor of certifying a class. But he comes ultimately to the conclusion, as Tim said, he says there remains one consideration of very great salience to the determination of this case. Is there a cause of action raising a triable issue? And then he analyzes that and comes to the conclusion, and I think not without recognizing the difficulty and the consequences of this, he says the matter may be framed as one of weight, and this is ultimately coming to deciding whether it's in the interest of justice to certify or not. He says the absence of a cause of action weighs too heavily to permit of certification. It is also a matter of logic. Why would a court trigger the machinery of a class action to determine something that does not exist in law? To do so would be to place a ghost in the machinery of justice. And beautifully written. And then he says, of course, as Tim has signaled as well, he says that shareholders are not left without remedies. What they should be doing is pressuring the companies to pursue alleged wrongdoers, whether it's the directors, whether it's auditors, any other wrongdoers. And then, of course, he also talks about, he says the Companies Act makes, as he calls it, generous provision in Section 165 for shareholders to require the Steinhoff companies to commence legal proceedings. So he says you should be getting the company to go and sue, or you can step in if the company won't do that. And I think it's worth touching, Tim, just very briefly on the 165, the derivative action procedure, because as you pointed out, the Act now replaces the common law. You no longer have any rights in common law. You only have an act. You only have a right, sorry, in terms of the Act if you wish to pursue a derivative action. And obviously, what is a derivative action? It's where the shareholders are permitted to step into the shoes of the company and effectively pursue an action or proceedings which the company for some reason has chosen not to. We have been involved in various derivative action procedures. They're obviously relatively new under the new Act. I must say that our view is that the procedure which has been put in place in terms of 165 is a relatively cumbersome procedure. It's quite a difficult procedure. It's not necessarily expensive, but it's not without expense. And really, what first the procedures commenced by a shareholder demanding of the company to say you must institute these proceedings. I want you to commence or continue some legal proceedings. The company has an off ramp immediately. Within 3 weeks, it can apply if it's persuaded, and it can persuade the court that the demand is frivolous, vexatious, or without merit. The court can dismiss the complaint right there. If not, then what the company must do is it must appoint an impartial person or a committee to investigate, and within 60 business days, so it's a relatively long time, the company must then either institute the proceedings or advise the complaining shareholder that it's not going to institute the proceedings. And it's only then that the shareholder can go back to court and say, and that they're in limited circumstances. It's quite a complicated section, but there are limited circumstances in which the shareholder can then reapproach the court and ask for the court to permit it to pursue the derivative action. So insofar as there is that remedy, of course it's there. It is, as in our experience, it's relatively cumbersome, and it's one which I think shareholders will take relatively cold comfort in. Of course, in a situation such as Steinhoff, it would give them cold comfort anyway, because even if the company were successful, because of the negative equity which I've described, most depending on the balance sheet, obviously, most benefit which might from a derivative action would in any event go to creditors rather than the shareholders. So they're unlikely to be persuaded to pursue that.
Yeah.
Yes.
James, if I could just come in there on the derivative, because I have been involved in actions on both sides, and it is a fairly cumbersome process, but it is a process that seems to work on the face of it, and it does put the board under intense scrutiny. Once the demand is made on the company, if it's a proper and valid demand, the company has to appoint an independent person to do a report and an investigation into the allegations. And there the board is very much under scrutiny. And of course, if the board doesn't follow a recommendation, to sue, then of course that's where the derivative comes in, where the complainant can then apply to court. Obviously it's expensive, it's an opposed process, to get an order to bring those proceedings. Can I just take that opportunity to try and answer a question that's popped up, because we are on the derivative action. Someone has asked the following question. Since a company's decision is essentially determined by the board of directors, isn't there a risk of self-protection by directors, i.e., a conflict when it comes to claims against directors? I'm going to try to answer that question as I understand it in two ways. As you know, in many cases, it's usually the ex-directors who get sued because the new brush has come in. So there shouldn't be a conflict in that case, but there are obviously worries about things like prescription and the passing of time. But I think the real answer to that question is the derivative action, because that takes away the question of conflict in the sense that if the directors retard or impede the bringing of claims against, for example, themselves, where in fact they would have to recuse themselves in any event from meetings to deal with derivative action. But that is where the shareholder can step in and bring the claim on behalf of the company against those directors. So the derivative action takes you past, I think, the conflict that will obviously be there because it's the human condition. Hopefully that answers that question. Thanks. Back to you, James. Sorry if I interrupted your flow.
No problem at all. No problem at all. Thanks, Tim. I think there's really two questions which remain that we'd posed ourselves. The one is there a future for shareholder class actions in these circumstances? And it's quite a difficult question, Tim, because if one looks at other jurisdictions, if one looks at Australia, for example, every time there is a move in the share price by more than a few percent, lawyers start writing letters threatening the board. But obviously, if it's linked to a particular board action, or can be linked to a board action or some potential failure by the board, people start writing letters of demand, and there is a thriving industry in alleged shareholder claims. But interestingly enough, there's very little jurisprudence. So there's an enormous industry, and shareholders are very active, and obviously the industry supporting them and supporting shareholders' claims is very active and intimates claims and brings claims. But there have been almost no decided judgments on those kind of claims, because on both sides probably the company and the board and their insurers generally don't want to avoid a precedent which might be adverse, and the same goes for the potential claimants. So in South Africa, though, I think we have, particularly in the Untitled judgment, we have a very sympathetic reasoning and effectively view in favor of shareholder class actions, other than for the legal difficulties expressed. And Tim, I don't really see, principally, as a matter of principle, I don't really see how one can get beyond that unless one can show the special relationship as you've referred to, or some other legal basis for a claim. I simply think that you're not going to get off the ground. You won't get certification. So it is a very interesting question, whether there's a future for shareholder class actions based on our current law, and particularly when one looks at reflective loss, because that's ultimately the loss, which is really how shareholders feel the loss. I think I have to say that it's not going to be a thriving industry.
Yeah.
I see, Tim, there's a question from Jan Kruger. He says, it seems from the discussion that Section 218 then has no effect or purpose. I don't think you'd agree with that, Tim.
It's a difficult one because the courts have found that you cannot rely upon 218 on its own. But I think to make sense of it, one is relying upon 218 as an enabler section, but you will have to couple it with another section which specifically provides for the liability and the reasons for it and who it's against and who owes it. So you're using 218 together with another section. But that, of course, then begs the question, do you need 218 at all if you've got a section that creates the liability? So I think it's a very valid question, and it may, in fact, be correct in due course. That's probably the best way I could deal with that. Just to come back to what James is saying on reflective loss, it's an interesting dynamic because, and it's a kind of academic thing, because when dealing, the theory then is that a company in recovering its loss, that then corrects the share value or the shareholder loss. And we all know that looks very nice in an exam answer, in an academic scenario, but in actual practice, the one might be very different to the other. So you've got that one dynamic playing against the other, which is where the courts seemingly have closed the door to an unidentifiable amorphous group of people from pursuing claims against directors or auditors. So, and saying in effect, those claims must be brought by the company. That is the dynamic, and I'm sure there are going to be many more decisions, writings, and findings following these cases. But as we know, the law moves very slowly, so it could take a few years. Thanks. I think that probably deals with the last question as well, about whether directors of companies no longer need to fear class actions by shareholders based on their conduct as directors. Subject to you, James, I think that fear is greatly diminished by what is now the current law. But I emphasize it's the current law, and I think it's going to develop in various ways and in different directions.
I'd agree with that, Tim, completely. And I think unless there's some statutory intervention, such as there's legislation in New Zealand, for example, where there are statutory rights, which it's referred to in the African Bank judgment as well, where specific duties are created in favor of shareholders. So unless we have some statutory intervention, or as you suggest, maybe a significant departure from the existing principles, I certainly think that the prospect of shareholder class actions, other than where you've got specific relationships, specific special factual relationships, I think that they are significantly diminished. I would suggest on the basis of these two judgments. I'd agree with that, Tim.
Yes. I think we've certainly gone over our scheduled time, and people are very busy. And I also see there are no unanswered open questions on the board, so we should perhaps get out of here while we can, before any others mount up that we can't answer. But I'd like to thank you all very much for your time. Thank you, James. And I wish you all a very good day. Thank you very much.
Thank you, Tim. Thank you, everyone, and thanks for attending.
Thank you. Goodbye.